If you have ever lost a loved one, or maybe you've started having conversations with a loved one about what happens when they pass, you quickly realize that it can be overwhelming.
I went through this in 2012. We were just talking about this morning when my father passed away. There's a lot to take care of. Things you just wouldn't even imagine. Estate planning attorney Philip J. Ruce from the Stone Arch Law Firm is here with a little bit of advice. Philip, always good to see you.
Thank you. So good to be back.
So let's start with this. Establish what an estate is. I think right there is an interesting thing, because when some people think of estate, you're thinking, oh, estate.
Like a big house
it means
somewhere.
Anything that they've got.
It does sound like some huge thing. Anybody who passes away is going to leave behind assets and some debts, and how we pay those debts, how we distribute those assets to family or wherever it's supposed to go, that is the estate.
So how do you deal with handling an estate? Is it a will? Is it a trust? Is it a combination of multiple things?
It depends a little bit on what kind of plan someone created, if any. If there's no will at all, no trust or anything of that nature, we are going to use Minnesota's backup rules. They're called the intestacy statutes, but they're the backup kind of defaults that we all use if we don't have a document. That we'll use those statutes to go through probate and nominate or appoint a personal representative. That's like the executor. We hear that term executor a lot. That's the person who pays debts, distributes the money, distributes the house, sells the house, administers the estate, etc. If we have a will, that's going to show us, that will document itself is going to determine who is going to be in charge. If that person can't act, who's next? Some people want to avoid probate altogether. If that's the case, wills are the wrong tool. Wills control probate. There's something called a revocable trust. Assets pass through this thing and are distributed probate free, and that's going to have a successor trustee, but it's the same job. If you are nominated as a personal representative, a trustee, etc., you don't have to do it. You can take a pass. You can resign from that, and it'll go to the next person in line in the document or the next person in line in the statute.
So do you want to have a trust versus having it go through the state? I mean, tell me the benefits of that and why you would want one over the other. Obviously, you have more control with a trust.
What it comes down to is here's the thing about probate. So probate is a court process. So if you have a will document, we're going to use that to take us through this court process. If we don't have a will document, we're going to use the backup rules. But either way, we're going to court. And court can take a long time. Probates vary depending on the county, but right now it's tough to get one started, more than, fewer than 9 months maybe from the date of death. Wow. It's public, so whatever I have, any debts I have, that can become public knowledge, as can my will, because that's filed with the court. And it can be expensive. It's almost certainly going to involve an attorney. And between those three things, some folks want to avoid it, and that's where this revocable trust tool comes into play. It's a will replacement. Assets pass through this thing, are distributed out the other end without opening a court hearing at all.
So what do we start with in this process? If there's a punch list of things you need to do, where do you start with that?
Well, the first thing we want to do is take a breath. Oftentimes we've lost someone and we don't need to rush into this. There's some folks, I think, who feel like they need to get this settled right away. You have up to 3 years to start a probate, so there's plenty of time. Take some time. For those that want to get started, those that want to jump in, 3 steps. First one is you want to gather important documents. So we're going to look for that will. If we can't find a will, talk to that attorney that prepared it, hopefully. If we don't have a will at all, again, we're going to use those statutes, but we still need to find bank statements, maybe real estate documents. We had done a segment here previously about digital estate planning, and sometimes that can help with tracking down those bank records. The next step is we want to do an inventory of our assets. So hopefully those documents, those records are going to help us understand how much money is out there, retirement accounts, bank accounts, investment accounts. Also, though, what kind of real estate are we going to need to do an appraisal? Usually you'll hold off on that until that personal representative is actually appointed. But at that point, we want to know how much is out there, what kind of assets. And then lastly, we want to have our strategic plan. Very importantly, there is an order in which debts are paid. Certain creditors have seniority over others, and we don't want to pay those out of order. Not only that, but the will document probably has an order in which the distributions need to be made to beneficiaries. We don't want to distribute things to the wrong people in the wrong order.
Yeah, talk a little bit about that, because we kind of teased at the top of our show. I had no idea that bills had to be paid in a certain order, and I, you think somebody dies, oh, they left me $10,000, I'll take my $10,000. They may not realize they need to wait 9 months, a year, even longer until everything's taken care of, and then that money can come out, right? How does that work?
So a couple of the biggest mistakes that we see, one of them is paying things out of order, but also paying things too or distributing money to the beneficiaries too early.
Yeah.
So everybody wants their money sometimes, depends on the family. Of course, a lot of families are very amicable, but sometimes you get one where they want the money a little more quickly. And if that distribution is made before we're able to pay these bills, you're going to be asking for that money back because those creditors have to get paid first. Yeah, again, that's a very difficult conversation. Absolutely. Mistake number 2 is making a commitment to a creditor without talking to your attorney first. They want their money, and if they're talking to you and you commit that money, you may have made a pretty big mistake because, again, there could be other creditors before them. Probably easy to guess that the tax man is number 1 on there, right? And then there's certain secured debts. Unsecured debts, credit cards are really sort of at the bottom. And we don't want to get out of order just because we're going to end up having to explain that to the beneficiaries.
On that note, can the estate default on some of those debts that might be outstanding?
Yes.
Does a credit card debt, does a medical debt stay with you even though you're gone?
That's a great question. It's called filial laws, and we don't have them here. And what it means is if an estate is upside down or insolvent, like a bankrupt estate, the beneficiaries aren't going to get anything. The creditors still have to be paid to the extent that they can be paid. But if there's no money left, the judge will eliminate those debts and rule them to be it's an insolvent estate, so those would ultimately go away. It would not pass on to the children.
What if you can't find, like, what if someone passes and you can't find a will or a trust, and you think, like, maybe there was a conversation?
I can walk you through that one.
We run into that question, don't we? Yeah, that's challenging, especially if there's like an idea or a rumor that a will was created. Like, was it? At our office, Stone Arch Law Office, we like to tell people that estate planning works best in the light of day. So if you do have a will document, tell people you have it, tell them where it is so that they can find it. If you have an idea of who the financial advisor was, sometimes that financial advisor has a copy. If you have an idea of the attorney, absolutely contact that attorney. We do encrypt electronic copies for our clients and hang on to them, but someone has to ask us for them because we don't always know what's going on with that family. If there is no will, ultimately we're going to use those default statutes. If we can't find the will, the judge will say we're going to proceed as if there's no will, and we're going to use those backup rules.
This was one thing that I noticed that I'd never really thought of when we went through this process. The funeral home asked me, how many copies of the death certificate do you want? And I'm like, 2, or, I didn't know. 1 for me, 1 for my sister. And they're like, are you sure? And I'm like, how many do you think I need? They're like, I'd start with 20. Like, in order to, and I was the executor, in order to take care of any single thing, you've got to prove that
close
you
accounts.
You have to just set the simple thing of proving that someone has passed.
And they all want original certified copies, and photocopies won't work. And you're going to be sending out multiple things to multiple accounts. So you'd think you could give them 1 certified copy and then get it back and go to the next, but you're doing everything at once. 10 to 20 is not wrong. We usually say at least 10.
And to do that, like, at that moment, because otherwise you've got to go through that whole process where you got to, rigmarole of government, always making things easy for
everything moves slowly. Patience is a virtue, and it's challenging, especially in times like that. We have quite a bit of information and resources on our website if folks are interested. In fact, we have an ebook that talks about the first steps of probate. If you go to Stone Arch like the bridge, stonearchlaw.com, scroll down a bit, couple free resources, tons of videos, tons of information, and certainly if there's any questions, give our team a call.
Excellent.
Yeah, great information, Philip. Great to see you again.
Good to see you.
Thank you again. We have posted that contact information for Philip and his team, Stone Arch Law, at minnesotalive.com. You can check that out.